For over 1,000 years, the court system has been trying to find the best way to answer the same questions. And the system we landed on began life as a religious ritual where people would be boiled alive. So buckle up, because this is the history of the jury. I'm Brian. I make videos about civics and law. Please share this video and get it out there so people will see it. Civics videos are not very popular and they need to be. So comment, tell me if you've ever been on a jury. Did they boil anyone alive? Okay, you ready? Let's do this. The entire legal system revolves around answering questions. And figuring out the best way to answer those questions has been a struggle for thousands of years, which is why law has been such a hot topic through civilizations, philosophers, throughout human history. So let's start with how the questions look today and how we answer them. Let's say Mike is arrested for trespassing into Victoria's house. Well, Mike is accused of trespassing. So 1, what is trespassing? And 2, did he do it? The way we look at these questions today is to divide them into questions of law and fact. What is trespass would be a question of law. Did Mike trespass would be a question of fact. And generally, the way we handle this in court is that a judge answers the question of law, so the judge will explain what trespass is, and then a jury will answer the question of fact, looking at the evidence, looking at the judge's explanation of the law, and deciding whether Mike did what the judge described. This is how we divide up the questions in court today. First, we appeal to the law, what is trespassing? Then we appeal to the facts, did he do it? But as sensible as this may seem, it took us a really long time to get here. So we're going to go back about 1,000 years and see how we got to this point by looking at how the judicial system used to answer these sorts of questions before we came up with this framework and this team of a judge and jury to answer these questions. I'm going to start at an arbitrary point in time around 900. Probably anything before 1100 will work, but 900 seems like a good starting point. And we're going to see how questions were asked and answered in the precursor to our legal system in England in the year 900. Before the invention of juries, questions still came up before the judicial system, right? Crimes were committed. Is the person guilty or not? This person stole my land. Well, did they or didn't they? So how did we answer these questions before we had a judge and jury? Questions were basically answered in 3 major ways. When a judicial question came up, it would still be answered in a trial, but the questions in the trial would either be answered by a wager, a battle, or an ordeal. So let's talk about what each of these are. Now remember that in our current system, the judge and jury appeal to law and fact. So as we talk about these 3, we're also going to discuss what each of them appeal to. First, we're going to talk about a wager. Now, a wager, or a wager of law as it was called, was usually used to settle a question around a debt, or maybe something where collateral had been used, and there was a question of whether you'd returned the collateral or not. And a question would be asked, does the defendant owe a debt? And the question would be answered by the defendant swearing an oath and saying, no, I do not owe a debt. And that's it. Well, not really. See, somebody's oath on its own isn't quite enough. But this was an appeal to that person's reputation. Because when this guy came and swore he didn't owe a debt, he would bring 12 people with him. And those 12 people wouldn't say, no, this person doesn't owe a debt. What they would say is this person's oath is good. Generally, this guy has a good reputation. And therefore, the oath that he swore that he didn't owe a debt is a good oath. And if 12 people came along and confirmed that oath, confirmed the reputation of the person giving the oath, then that was enough to answer the question. That person did not owe a debt. And that was the answer to the legal question. Now let's look at trial by battle, which is pretty much what it sounds like, but only applies in very limited circumstances. See, people didn't really own land back then. It was really all owned by the king. But you were given something similar to an ownership right. The problem is that the way that ownership right was given was very ceremonial. You would get down on one knee and swear loyalty to whomever was giving you the right to the land. That person would put a clump of dirt or a twig in your hand, and that was pretty much it. Nothing was written down, nothing was recorded. Basically, there's no evidence. The only real evidence are the people sitting around you who watched you get the clump of dirt. And that's a big problem because after a while, witnesses start to die. But these rights to land ownership could last for generations. So what happens 100 years after you've been given your clump of dirt if your son decides to go off and fight the Crusades for 5 years? And when he comes back, the land has been occupied by a new person. And your son says, this is my grandpa's land. You have to get off of it. This is mine now. And the new guy's like, I don't see your name on it. Well, we settle these questions with a trial by battle. Here's how it works, and it's kind of hilarious. Each of the parties hires someone called a champion, which is a big burly dude who fights for a living. And the champion swears an oath, we're back to the oaths, that on his father's deathbed, his dying words were that he watched your grandfather get the clump of dirt in his hand. For some reason, it always has to be his dying words. So each of the champions swears that that was his father's dying words, and then they fight to the death to defend their oath. Except it's usually not a fight to the death, it's often just a fight until nightfall. And if the fight lasts until nightfall, then the defendant gets to keep the land. If the defendant's champion gives up before nightfall, then the plaintiff gets to keep the land, and that's how we decide who gets to keep the land. But once again, this has nothing to do with the law of land ownership. This has nothing to do with the facts of who actually owns the land. This has to do with who hired a better champion, or which one of them was stronger. This is an appeal to strength. But once again, it is not an appeal to law or fact. We have an appeal to reputation, an appeal to strength, nothing yet about what actually happened or what the law is. Now, let's look at the ordeal, and this is where things get fun. The ordeal is used to answer questions about crime. And we know the ordeal has been around since at least like the 600s. Now here's what happens. The person in charge, a judge or whatever, asks the question, is this person guilty of this crime? And to answer our question, do we look at the law for a definition of the crime? No. Do we look at the facts for what actually happened? No. We put the person through an ordeal that will likely kill them and ask God to save them if they are innocent. So, there are 4 ordeals. There's the ordeal of the cauldron, where you are essentially boiled to death. There's the ordeal of cold water, where you are essentially drowned, and if you float, you are guilty. There's the ordeal of the fire, where you have to carry a large piece of essentially molten hot iron, and then your wound has to heal in a certain number of days, usually like 3 or 4, like a miraculously short number of days. And finally, there is the ordeal of the morsel, which is my favorite. The ordeal of the morsel is reserved for the clergy. A feather is stuck into a small piece of bread. You have to swallow the piece of bread without choking on it. Most of the time, you are acquitted. I am guessing the only time you aren't acquitted is when someone puts like a giant feather in there because they really don't want you to be acquitted. Anyway, those are the 4 ordeals. But the point is, once again, we are not appealing to fact or law or anything like that. Now we are appealing to God. These are the 3 ways that judicial questions were answered before the 1100s. And then along comes Henry II. And part of what Henry II did was to really try to clean up the administration of justice in the country. And he did this in a lot of different ways. And some of these things started before Henry. For example, this is kind of cool. In criminal cases, there's this point where the judges start to call together like a group of people who kind of look like a jury. And they're asked to formally accuse people of crimes before they're put through their ordeals. And while that may not sound like a big deal, it is sort of like a new formalization of the process. And that formalization starts to sound a little bit like our modern grand jury, which I think is kind of interesting. But again, neither here nor there. The wager of law actually sticks around for quite some time, but only in cases related to like debt kind of stuff. But the first place where we start to see a breakdown is in the trial by battle. Because Henry creates this thing called the possessory assizes. And assize means session, sort of like court case. Because he sort of realized that this isn't really working. So first, he changes the question that we're asking. Because nobody's going to be able to go back 100 years and find out what really happened. So instead, the question becomes, who was possessing the land 5 or 10 years ago? This guy says he went away to the Crusades for 5 years. And when he came back, this new guy's standing on his land. Is he right? It's a lot easier to find witnesses for 5 or 10 years ago than it is for 150 years ago. And so Henry comes up with this idea, why don't we call all the neighbors in? And we'll ask them, was this guy living on this land 5 or 10 years ago before he went off to the Crusades? Did this new guy come in and just take his land? And then he just sort of polls the neighbors. Raise your hand if that's what happened. And all of a sudden, we've stopped appealing to reputation or strength or God. And we've started appealing to facts. Something has just significantly changed. We have something that's starting to look like our first jury. Now, one of the significant differences between modern juries and what we're talking about right here is that the people who are brought in to give evidence also decide the fate at the end of the case. Essentially, they decide which way it goes based on what they've seen and experienced. They don't really give anyone evidence, they just think about what's in their head. And that's the way these juries are actually going to go for the next couple hundred years. But we'll get there in a second. So these possessory assizes are sort of a first glimpse of what's going to happen. But now we also got to fix these ordeals, because this is ridiculous. Unfortunately, it's not logic that kills off the ordeal. It's actually something a little more political. Because Henry goes off and makes enemies with the church. And because God is involved here, so is a priest. So every time one of these ordeals happens, a priest has to have a church service. And when the Pope gets mad at Henry, he forbids any priests from providing any of these church services anymore. So suddenly, these judges stand up there, they say, is this person guilty or not? And they're about to order the ordeal, but they can't. Before, they would have asked God, and it would be really inappropriate for them to go from asking God for the answer to giving the answer themselves, because that would be like they think they're God. So that would be really bad. So they have to come up with something else fast. And so they gather all the people together from the village. They say, This person's accused of a crime. Did they do it? And the people from the village say yes or no, and that's how they decide whether the person's guilty or not. Now, is this a great system? No. You can see the problems here. And it's going to take them about 200 years to separate the people giving evidence from the people deciding guilty or not guilty. But this is a big step in a different direction. We have now come up with a new way to answer our questions. A jury can answer our questions, and instead of appealing to these other things, the jury can appeal to the facts. And this is a really big innovation. We're not going to boil people in hot water to find out whether they're guilty anymore. We're going to ask what happened. And a little while after this, we're going to hone the process a bit. Like, we're going to stop allowing the accusers to be on the jury. That's sort of a problem at the beginning. But from about the 1400s to the 1700s, the legal system in England is really going to hone this system into a good way to develop law, compare it to facts, and determine in both criminal and civil cases what the legal outcome should be. And by the time we get to the founding of America, the jury system is a really beloved and cherished thing, particularly because it allows normal people to involve themselves in the legal system in a way that there are a lot of barriers keeping them out of other institutions. And as the arguments developed over the writing of the Constitution, in the Federalist Papers and the Anti-Federalist Papers, as Alexander Hamilton argues in Federalist number 83, while there are some cases where juries may not be necessary, no one would suggest that the jury is not fundamental to the application of justice in a lot of cases, particularly criminal. So these are the roots of the jury system that we have today, how we answer questions of law and fact, and eventually we even replace the wager of law with the jury. But at some point I'll get into the writ system, and I'll explain how the different types of writs were used with juries or with these other guys, which made them more or less popular. But I hope this was an interesting bit of history, and hopefully you can see why we're better off with the system we have today. Being boiled in a cauldron to prove my innocence, not ideal. Let me know if you have any further questions. I'm happy to answer everything you guys have. I really want to get more into the modern juries as well, but this was already running a little long. Thank you so much for the support you guys have been giving me. I can only keep doing this with your support. Again, please like, comment, get this out there for people to see, and keep learning more about your system of government and law.